Hello and welcome everyone. Thank you for joining today's webinar dedicated to the secondary use in the context of the European health data space. My name is Nathalie Poupard and I am counsel in the Tech and Data team at Fieldfisher Brussels office. I am delighted to be joined today by two of my colleagues, Sonia Gracia. She's Principal Associate at our Barcelona office, and Sarah Tedstone, partner at our London headquarter office. This session is being recorded and will be made available on the Fieldfisher YouTube channel. If you have any questions during the presentation, feel free to submit them via the Q&A box, and we'll do our best to address them at the end of the session. Also, for your information, the slides will be sent out to you after the session. So this session is designed to break down the key elements of the secondary use in the context of EHDS. As you know, EHDS is not just another regulation. It is the first legislative initiative to emerge from the European Strategy for Data, a broader EU vision launched in 2020. In today's session, we will focus on what companies should know about secondary use in the context of EHDS. We'll start with a short introduction and tackle territorial scope. Then I will walk you through the data access process while providing information on the key definitions and concepts that you need to be familiar with, such as, for example, health data access bodies, data holders, data categories, data catalog, and so forth. Then we will dig into the frequently asked questions. So as I said, the EHDS is the first legislative initiative to come from the European Strategy for Data, which is the broader EU vision launched in 2020 to create a single market for data. It promotes the free flow of data across sectors and member states while ensuring safeguards for privacy and security. It was published on the 5th of March of this year and has entered into force on the 25th of March of this year. So what is the EHDS aiming to achieve? Well, the goal of EHDS is to really empower every citizen to access across Europe, to access, control, and share their electronic health data across borders. This means that whether you're in Brussels or Milan, you should be able to retrieve your medical records securely and share them with providers as needed. This is called primary use. In the context of EHDS, EHDS is also ensuring a common legal and technical framework so that data can be exchanged. The idea is to create a single market for electronic health record systems by setting interoperability standards so that, I would say, systems can talk to each other. But the goal of EHDS is also to establish clear rules for the reuse of data. So this is the secondary use. Why? Because, as we all know, health data has such a huge value for research, innovation, public health, and policy making. So these are the main goals, I would say, of EHDS in a nutshell. Let's have a look now at the territorial scope of EHDS. Who is covered? Well, the EHDS applies to health data holders that are established within the European Union. So that's the principle. This includes hospitals, clinics, research institutions, and companies that are based in the EU and that, of course, handle health data. So what about organizations outside the EU? Well, if a health data holder is established in a third country outside the EU, the EHDS does not apply to them unless they have a branch office or another form of establishment within the EU. So for example, a non-EU based sponsor of a clinical trial would only be subject to EHDS obligation if they have an establishment in the EU. In such case, the responsibility for complying with the EHDS obligation would fall on the EU-based establishment acting as a controller or joint controller of the data. Let's have a look now at this main concept of data holder. This slide breaks down the definition of a data holder under EHDS. So First, let's look at the entities that can qualify as data holder. These include a wide range of actors, as you can see on this slide. So what you will have is natural or legal persons, public authorities, agencies, bodies working in the healthcare sector. It also covers reimbursement services, developers of health-related products and services, researchers, mortality registries, and also union institutions. So essentially, anyone who holds or processes relevant health data can fall into this category. Next, you will need to apply the criteria. To be a data holder, an entity must make available data that falls under EHDS data categories and that they control. So to be a data holder, an entity must either have the right or obligation to process electronic health data or the ability to make non-personal electronic health data available. So as you can see, this is quite a broad definition, and that was definitely the goal of EHDS. So let's take some examples regarding the criteria. If a manufacturer of a wellness application designs the application in such a way that data is only kept locally on an app user device without the possibility for that manufacturer to access it, the manufacturer does not hold that data and thus would not require to make such data available. I will give you another example. A provider of a patient management system, for example, which would be processing personal electronic health data as a processor for an hospital, it would not qualify as a health data holder for those data because it does not meet the criteria of being a controller for this processing. So in this situation, it would be the hospital as a controller that would qualify as a health data holder. And so finally, we have also some exclusions. Independent researchers and micro enterprise, which are not considered data holder under this definition. Why? Well, because this ensures that smaller actors and individuals will not be burdened with the same obligations. So this is for the concept of data holder. Another question is whether a data holder of personal electronic health data is always a controller. And what about joint controllership situation? Well, as far as personal electronic health data is concerned, a health data holder is always a controller. So that's for once is a simple situation where a processor processes personal data on behalf of a controller. It is the controller who is subject to the obligation of EHDS as a health data holder. In joint controllership situation, it is for the joint controllers to organize themselves and see who will handle, for instance, obligation with health data access bodies. What about those health data access bodies? Well, health data access bodies, they are a key element in EHDS. Their main role is to facilitate and oversee the secondary use of health data. They are, I would say, gatekeepers and coordinators. They ensure that requests for access will comply with EHDS, with privacy and security standards. Well, each EU member state must set up at least one of those health data access bodies. So this is what is foreseen by EHDS by March 2027. Some member states may want to choose to create more than one, and that is okay. It really depends on their national system and needs. In the meantime, and this is interesting, there is an initiative to create a community of practice amongst these bodies. And the idea is there to foster collaboration and consistency across member states and to ensure an harmonized approach with EHDS. Okay, here's an overview of the generic data access approval process under EHDS. So how does it work, this data access process? The first step is obviously data discovery. So researchers begin by identifying what health data is available and would be interesting in the context of their research activities. They can browse via a trusted web portal that hosts those datasets catalog, which contain metadata describing available data set. So this is really the first step, data discovery. Then there is a permit application. So applicants can submit a data access application to the health data access body of their main establishment. And this application must include, for example, their identity, the purpose and expected benefits of the data used, the description of the requested data, the duration of access, and so forth. And then there is a review and a decision step. So the health data access body will review the application, make sure it's compliant with EHDS, and then it may approve and issue the permit, request additional information, or altogether refuse the application with justifications. Then there is the step of data preparation. So once approved, the health data access body requests the data from the health data holder. The health data access body will prepare the data, make sure it's anonymized or pseudonymized as it should be, and it will ensure also that it meets the quality standards. Then regarding data provision, data is made available to the applicant in a secure processing environment. This environment will restrict access to only authorized individuals, log all activities, prevent unauthorized processing, and also will be regularly audited. Then data can be used by researchers who can analyze the data within this secure processing environment. And the goal there is that results should be published within 18 months. And also those results must contain only anonymous information. So this was the data access process. Now let's have a look at the data categories. So these slides provide a structured overview of the minimum categories of electronic health data which data holders must make available in the context of secondary use. The classification spans 7 key domains that you find on these slides. So starting on the left, we have electronic health record and administrative data. This includes reimbursement claim, professional credentials. You have determinants of health, such as, for example, socioeconomic and environmental factors, as well as aggregated data on healthcare system and pathogen, and molecular and genetic data. On the right side, you find device-generated health data, such as personal metrics from medical device, for instance, or wellness applications. You have registries, biobank data, so coming from public health registries, mortality data bank, medicinal product database, and so forth. And you also have clinical research data. And this includes, obviously, clinical trials, investigation, and performance studies. And finally, you have the post-publication research data, such as cohort studies, surveys, and questionnaire. There is a document that is called Frequently Asked Questions on EHDS, which has been published by the European Commission. And there you will find very interesting information around data categories. For instance, there is a synthetic table which provides example for each category of data that data holder will have to make available. And that's a very interesting tool to see whether some of the data you might produce is a data category. Okay, so health data access bodies have an obligation to maintain data catalogs and implement quality label. In the context of EHDS, what do the terms data catalogs and quality label would refer to? Starting with data catalogs, well, health data access body, they must ensure that all data sets they manage are listed in a public, standardized and machine-readable catalog to ease the process. This catalog should clearly describe each data set, its source, content, and access condition. The goal there is to improve transparency, obviously, and make health data sets more discoverable for secondary use, like research. Moving to the data quality and utility label, well, health data access bodies are required to access and label the data sets they manage. These labels, they will help users understand the relevance of the data for their specific needs. So those labels will be really helpful. For your information, these labels will be mandatory when the data set has received public funding. Okay, now that we have covered, I would say, the main concept of EHDS and walk through the data access process, let's move on and explore some of the most interesting and frequently asked questions so that we have listed here. What are the allowed and prohibited purpose for secondary use? What safeguards for intellectual property and trade secrets protection does the EHDS include? How are data minimization and purpose limitation implemented? How can individuals opt out of secondary use? Who is responsible for pseudonymization and anonymization? And how does EHDS interplay with the other regulations? Let's have a look at this. To you, Sarah.
Thank you, Natalie. Well, secondary use is defined within the regulation, and it's defined in terms of a list of uses other than the initial purpose for which they were collected or produced. And the list includes, as I've set out on the slide, public interest, use for public interest in the areas of public or occupational health, such as activities to protect against serious cross-border threats to health, public health surveillance or activities ensuring high levels of quality and safety of healthcare, including patient safety and of medicinal products or medical devices, subject to a caveat I'll mention later, policy making and regulatory activities to support public sector bodies or union institutions, bodies, offices or agencies, including regulatory authorities in the health or care sector to carry out their tasks. For statistical purposes, such as national, multinational and union level official statistics related to health or care sectors, educational teaching activities in health or care sectors at vocational or higher educational level, scientific research related to health or care sectors that contribute to public health, health technology assessments, or that ensure high levels of quality and safety of healthcare, of medicinal products or medical devices, with the aim of benefiting end users such as patients, health professionals and health administrators, development and innovation activities for products or services, training, testing and evaluation of algorithms, including in many medical devices, in vitro diagnostic medical devices, AI systems and digital health applications, and improvement of the delivery of care or of the optimization of treatment and the provision of healthcare based on the electronic health data of other natural persons. So the one caveat I mentioned, though, is the first three subsets that I mentioned, which are sort of the public interest policy making and national and multinational statistical purposes, are reserved only for public sector bodies and union institutions, exercising tasks conferred on them by union law, including others carrying it out on their behalf. So those three are of more limited application. The regulation makes it clear that it doesn't affect. It isn't the only way that this can be done. It's made clear in several areas. So where there is, a framework of contractual or administrative arrangements between public or private entities already, it won't affect that use. And then we'll go on to the next slide, which will deal with the prohibited aspects. So the regulation's quite clear about what is prohibited, not all in one section of the regulation. Actually, it has to be drawn in some places by inference, but it is quite firm about what cannot be done. So first of all, it makes clear that this access will only be granted if the requested data is to be used for specific purposes in closed, secure environments and without revealing the identity of the individual. But beyond that, expressly, it prohibits use that involves taking decisions that would be detrimental to a natural person or a group of natural persons based on their electronic health data. Decisions here, we're talking about sort of legal, social or economic effects or similarly significant effect on those natural persons. We've seen similar language in other European regulations, so possibly not a surprise here. Also, anything that involves taking decisions in relation to job offers, offering less favourable less favourable terms in the provision of goods or services, including the exclusion of such persons or groups from the benefit of an insurance or credit contract, modifications of their contributions and insurance premiums or conditions of loans, or taking any other decisions which result in discriminating action against them on the basis of the health data concerned. Also banned is carrying out any advertising or marketing activities, including in relation to health professionals, developing products or services that may harm individuals, public health or society at large, such as illicit drugs, alcoholic drinks, tobacco and nicotine products, weapons, or products or services which are designed to create addiction, contravene public order or cause a risk for human health, carrying out activities which conflict with ethical provisions laid down in national law, so potentially some deviation here, maybe some inconsistency, and also anything that attempts to re-identify natural persons. It's made clear at the outset that we're not supposed to reveal the identity of the individual, so not surprising that it's prohibited to make any attempt to re-identify the individual, and anything that develops harmful products. So that's specifically prohibited, but then also inferring generally from the regulation elsewhere, prohibited generally is providing access to or otherwise is making available electronic health data to third parties not mentioned in the data permit, downloading personal electronic health data outside of the secure processing environment or use is not covered by a data permit, and to use data to re-identify natural persons again. And then there's also some confirmation that this doesn't cover sort of law enforcement purposes. So anything where we're talking about the prevention, investigation, detention or prosecution of criminal offences or the execution of criminal penalties is not to be considered as a secondary use purpose under the regulation, and anything therefore done by the courts or other entities within the justice system isn't caught, and those bodies are not to be considered health data users for the secondary use. It's a fairly comprehensive list, but probably not surprising. These are all fairly much in the public interest, and the purpose of this is to facilitate very positive effects of data sharing, and we want to expressly prohibit any harmful use or harmful effects.
Thank you, Sarah. Now we are going to address what safeguards are included in EHDS in order to protect intellectual property and trade secrets. As all of you may be aware, health data protected by intellectual property or trade secrets, such as clinical trials, investigations, studies, can be extremely valuable for secondary use and can drive innovation across the Union, ultimately benefiting patients. Can we do this freely? Innovation is overriding IP rights? No. The EHDS provides a balanced framework. On the one hand, ensuring that these rights are not an obstacle to the reuse of valuable data, and on the other, making sure that the protection is not undermined. This careful balance between enabling secondary use and safeguarding intellectual property or trade secrets is what allows Europe to foster innovation while respecting the legitimate interest of data holders, of their commercial interest. However, this is not the first time we see this kind of balance between public health and, for instance, trade secret protection, because it was already recognized in 2016 EU Trade Secrets Directive, which acknowledged that public health can serve as a legitimate interest to override trade secret protection. So we can see the EHDS, not the natural follow-up maybe, but one regulation that takes this kind of balance to new extremes. If we can go to the second slide. Before getting into the specifics of Article 52 of EHDS, which is the one that established these safeguards in order to protect IP rights and trade secrets, we wanted to clarify these two key concepts because sometimes are overlooked, especially when we are very focused in data protection. And from on one side, we have trade secrets, which is it will be health data. Consider when health data will be considered a trade secret when meets three criteria already established in the Trade Secrets Directive. The first one is that it is secret. It is not something that it's on the day-to-day business. And the second criteria, it has commercial value because it is a secret. And also, in this case, will be the data holder has taken reasonable steps to keep it confidential. Then is when a data set we can this is how we can evaluate if a data set that we are going to communicate to the health data access bodies has included health data or no. This is key in the scientific research field where most of the data sets will probably include trade secrets. From our experience, companies often neglect to inventory trade secrets simply due to heavy workload of other compliance tasks. Also, however, we see this as an opportunity to protect information from competitors, since accessing such datasets could compromise the competitiveness of a data holder. And also, we see this as an opportunity to improve different business of our data holders. The second concept that will be protected by Article 52 of the EHDS will be intellectual property rights. This we are more familiar with. Maybe an IP right is when something is original, novel, represents a creative expression or technical solution. Specifically in the field of EHDS will be technical solution. It is distinctive or identifiable and is lawfully protected. Here it becomes even clearer why identifying and registering these assets is crucial. Without proper registration, IP rights might not be enforceable. So that's why we think a good way to prepare for EHDS is to maintain a solid inventory of intangible assets using existing compliance tags, such as data governance frameworks, or when producing a ROPA, we can always add a layer of questioning regarding we will consider it a trade secret. This will be easily protectable by IP rights. Which will naturally help identify and safeguard these rights before granting access before the health data access bodies. Then if we go to the next slide, we have here in front of you the safeguards included in Article 52 of EHDS, which sets out how health data protected by intellectual property rights or trade secrets should be handled. First one, it will be health data holders who needs to notify the HDA, the health data access bodies, if their data sets contain protected information. That is why we consider that it was worth it to refresh the concepts of trade secrets and IP rights, because this is something that the data holders we will have to inform and the health data access bodies. When we will have to notify this that a data set contains something that could be protected by these regulations. Well, when submitting the dataset description for inclusion in the data catalog, as Natalie explained before, or later when a permit or request on such data is issued. That's also really key and important, and we will have to be aware of this request of access. Because maybe we can describe a data set at the beginning and don't consider that it includes trade secrets, but then after, yes, when we receive the request. So this is something that we will need to look up. And also we will have, data holders will have to justify why a protection is needed, why this is especially important for trade secrets because unlike registered IP like patents or designs, there's no pre-confirmation that a data qualifies as a trade secret without proper justification. So there's a risk of overclaiming. this would be regarding the way on how we are going to describe it. The second safeguard will be apply protective measures. This can be legal measures, organizational or technical, and may include additional contractual arrangements between data holders and users. Actually, the Health Data Access Body is responsible for deciding which measures are appropriate. And also, it is been said that the Commission will produce non-binding templates of agreements to that include the safeguards or the measures appropriate to protect IP rights and trade secrets. Finally, another safeguard, if the Health Data Access Body concludes that the protective measures are insufficient to safeguard the rights of the data holder, it can refuse the permit. In that way, we will ensure that data reuse can proceed safely, balancing innovation with the protection of IP rights and trade secrets. So we go to the next frequently asked questions. I think it's Sarah now.
Yes, absolutely. So how are data minimization and purpose limitation implemented? These are really important principles that underline this process, this data sharing provision. So where health data access bodies receive a health data access application, it's their responsibility to ensure that access is only provided to data that's adequate, relevant, and limited to what is necessary in relation to the purpose of processing indicated in the application. And in line with the data permit issued. So they also provide the electronic health data in an anonymized format where the purpose of processing by the health data user can be achieved with such data, taking into account the information provided by the health data use. Where the purpose of processing can't be achieved with anonymized data, and the burden will be on those making that suggestion to prove it, health data access bodies shall provide access to electronic health data in pseudonymized format. The information necessary to reverse the pseudonymization shall be available only to the health data access body or an entity that acts as a trusted third party in accordance with national law, which is consistent with recent guidance about anonymization and pseudonymization. So generally, the responsibility rests with the health data access bodies to ensure that this is adequate, relevant, and limited to what is necessary.
And now, how can individuals opt out for secondary use, which is one of the, in my opinion, huge topics also for this section of the EHDS regarding secondary use. I mean, it's obvious, and all of us know that individuals there will be able to opt out from secondary use. And when an individual exercises this right, data cannot be processed for new permits requests after opt-out date. Exception, and why there is an exception regarding the applicability of this opt-out request in order to guarantee the results of a future scientific research. And what does it mean? That the opt-out request will not affect processing under permits approved before the opt-out date. For instance, if I opt out today and there have been permits given like in 2021, 2022, before my opt-out date, this opt-out will not affect the reuse or secondary use of these other of the permits issued at that time. This is really important, and as I said, it's in order to protect the results of this scientific research or secondary uses that data users will be carrying out. Also, this opt-out is reversible. Individuals will have the option to reverse their decisions and to opt back in, which is really interesting. And maybe we will see campaigns in order so individuals re-opt in or allows data users to reuse their data for secondary use and to in the scientific field, for instance. Also, really important, and maybe something we haven't commented yet, is that member states must provide an accessible and easily understandable opt-out mechanism. This is something that happens along all the EHDS, and this is when it comes in handy that we have colleagues in Brussels, London, etc., because there is a lot of freedom for member states in the EHDS to decide in the how, in the real practical elements of the EHDS. And opt-out mechanisms are one of these sections that member states will have freedom in order to establish the specifics on how it's going to work out. It's funny that we have this webinar today because yesterday in Spain it was published the initial draft of the Spanish Digital Health Act, and it's already established that it's open for public consultation, and we only have like a first initial draft, but it's already included addressing this opt-out mechanism. And in the public consultation, there is a question asking patients, in this case, how eager or how probable they think they will exercise their opt-out right. So we will be very interested in the follow-up of these public consultations and what is the percentage of patients that will consider to opt out. Also interesting regarding opt-out is that there is no link between opt-out for primary use and secondary use. So we can have somebody that opts out for primary use. They don't want some data to be shared in their electronic health record, but they allow the secondary use and vice versa. So this will be interesting and also it may be burdensome for some data holders. Maybe they will have to differentiate which right is exercised in each individual. So this is something to look up. We go to the second slide. Also, opt-out right is not, it will always work out for the individual. There are exceptions and these exceptions, again, they will have to be provided by a member state's national law. That there can be exceptions where for secondary use, there's not going to be respected the opt-out exercised by the individual, but there are some conditions that has to be fulfilled in order to override this right of the individual. One of them will be, well, the conditions, we have them in front of you. It has to be an authorized requester, a public authority, EU body, or entity performing public health tasks, and this will affect the private sector for sure. Also, the purpose. It has to be essential for public health or high priority scientific research. Somebody remembers COVID, so I think they are thinking about this, and in this type of situations, there will be an exception to opt-out right. Also, there has to be no alternatives. The data cannot be obtained by other means quickly and effectively. Maybe here the federated data come in handy, we don't know. And also justification. The requester must provide a formal justification in order to override this right of the individual. And if we go to the second slide, we will explain you the requirements on the applicability of this opt-out right. First, it only applies where personal electronic health data can be identified. What does it mean? That if the health data holder cannot identify the person, the right will not apply. Opt-out will not apply. I cannot help to mention the Scania doctrine in GDPR, which already analyzes or establishes a subjective definition of personal data by saying that when somebody cannot re-identify a pseudonymized data set, then it's not personal data. This will be something that will relate to this kind of doctrine. Also, the health data access body may carry out additional steps to screen data against opt-out attributes in order to be sure that the data sets that it's being given for secondary use, it does not include any data from individuals that have opt-out. Also, a principle that GDPR professionals were very familiar with, it's the principle of data minimization. And in the opt-out for secondary use will be that a data holder should not process additional personal data to comply with opt-out, because otherwise it's not very logical to produce more information to opt out a person for use their data for secondary use. And finally, another measure or safeguard that could be applied to attend opt-out right for secondary use is that stripped out data when preparing data sets for secure processing environment. I mean, these will be like the broad lines or the lines that all member states will have to respect. But as I said, this will be something very local member state. Each member state will decide how they will carry out this right, and we will have to see how it translates in real life. And we go to the next question. Yeah.
So question is, who's responsible for pseudonymization and anonymization of the data? As I referenced before, it's health data access bodies that have this responsibility. They're charged with applying tested state-of-the-art techniques that ensure that the data is preserving the privacy of information contained with it and for the secondary use that's allowed. And they have to consider including techniques for pseudonymization, anonymization, generalization, suppression, and randomization of personal data. Interesting that this is state-of-the-art techniques. So, this needs to be monitored, kept up to date as things progress, as technology progresses. They need to prepare the data sets for the health data user as required under any permit and use, and should cooperate across borders. So when there's cross-border exchange here, they have to develop and exchange best practices and techniques which should include pseudonymization and anonymization of the data sets. So it remains to be seen what those best practices and techniques are established.
Thank you, Sarah. And last but not least, at least regarding these frequently asked questions, one of my last questions is how, and one that presents a lot in for privacy and tech professionals, is how the EHDS interplays with other regulations, because actually EHDS does not stand alone. It must interact with other EU regulations that we know really well. And in this section, we wanted to hint or explore its interplay with GDPR, AI Act, clinical trial regulations, medical device regulations, and AI Act. So the first one, and if you can go to the second slide, will be EHDS versus or how it interplays with GDPR. Natalie, at the beginning of the presentation, already said that EHDS defined that data holders will be considered controllers of the data sets. And processors, they are, EHDS doesn't address processors. However, sometimes processors, they act also as controllers when carrying out personal data processings, even when from data they obtain as data processors for their own purposes, for product improvement, for, I don't know, metrics. Then will we consider also data holders? What will happen there? We will have, for sure, we will have to review agreements, and we will have to look up better to this kind of secondary use of data of a data processor, or as I like to call them, shadow controllers or controllers in the shadow. Also, it would be important to know or to regulate contractually how at what extent a processor will have to collaborate with a data controller that is considered a data holder when sharing these data sets or permitting access. These are some challenges that they are partially addressed in the EHDS text, but we will have to look at it. We also have a strengthened data subject rights. I already talked about opt-out right, but for instance, for the primary use access right, it's like a GDPR access right, but with steroids, because it will have to be an immediate access under EDHS versus 1 month under GDPR. Also, EHDS give us or provide us lawful basis for secondary use, obviously, because it will affect personal data. So we will need a lawful basis. Fortunately, we already have this legal base to in Article 6 of GDPR and 9 to lift the prohibition of processing special categories of data. EHDS also addresses security obligations, expands the duties for controllers and processors. So we will have to see how our compliance efforts with GDPR interplays with EHDS, which I think is manageable for sure. Also, another regulation that affects EHDS, if we go to the second follow slide. It's the clinical trials regulations and medical device regulation. For interest of time, I'm going to focus mostly in clinical trials because EHDS runs in parallel with the clinical trials regulations and the city's platform. Here, the idea of EHDS, I think, is to enable sponsors and investigators to access broader health data sets for secondary research. However, data from clinical trials can only enter EHDS after the trial has finished. This will be very, very important to be aware of, unless the sponsor chooses to share it earlier, which I don't think any sponsor decides this. Well, we'll see. And also EHDS does not affect the special regulatory protections around marketing and authorization data. So this is also very, very important in regarding the CTR. I think that it's very spoken is that how it's going to affect EHDS to observational and retrospective studies. Because one of the open questions is whether EHDS framework might put pressure on how we conduct observational retrospective studies. Since the EHDS conditions access to health data for secondary use that Natalie already explained to you, it looks like there are going to be more requirements to access to this data, when today the only thing that they need to do researchers is to ask a ethics committee permit. We'll see, because in Spain I had the chance to participate in a conference conducted by the Spanish Data Protection Authority and some key stakeholders regarding research, and they said that it's something that every member state has to decide how ethics committees approving observational retrospective studies will work with health data access bodies. Also, another regulation that interplays with EHDS, and obviously it's our AI Act. All of us also are very familiar with this kind of regulation. And here you will see in the slide that we highlight the points in common that the EHDS and AI regulation have. But we think that focusing on secondary use, the most important aspect of this section of the EHDS is the allowance to use data sets for training algorithms. I think this is key. This is something that is going to push forward innovation in Europe and protecting patients, actually. So this will be another interplay with the AI Act. And also, if we go to the last slide, obviously, and there is how connects EHDS with Data Act. I mean, actually, EHDS is one of the first health data spaces that the Data Act enunciated. So for sure, they are related and maybe in a way overlapped. But when we focus on secondary use, the picture, I think, or I think a non-secondary use is not that there. We don't see that overlapping. First, unconnected devices like EHR systems or medical devices, patients that can access for voluntary share for research. I mean, this is something that is common with these regulations. And there's also a very interesting thing in Data Act that it will prohibit the use of data when it's against when it affects your competitiveness in the market. So maybe it's something that a health data access body take into account when assessing a data access request. So this is something also interesting from the data act perspective, and something that if you are already prepared for that act and you are in the health sector, you have a lot of work done. That's what the message we like to send. And that's it from the interplay of regulation. So Natalie, back to you.
Yes. Thank you, Sonia. So I would say last but not least, that's also an important question. When do we need to comply by? As you might know, EHDS will be implemented in several phases, given the large extent of preparatory work needed to set up the legal technical infrastructure to operationalize it. So from 2025 to 2027, we will have the secondary legislation phase, focusing on drafting, implementing, and delegating acts. And then from 2027 to 2029, it will be the member states' preparation phase involving the integration with the EU-wide infrastructure. So key provision related to primary and secondary use will apply from 4 years entry to force. So this means as of March 2029, regarding the first group of priority categories. So that's patient summaries, electronic prescription, electronic dispensation. And from 6 years, this means as of March 2031 for the remaining priority categories. So that is medical imaging, studies, test results, discharge report. So practically, this means for data holders, so like hospitals, labs, pharma companies, insurers, and so forth, that by March 2029 or 2031, they will be required to submit dataset description to the health data access bodies. And the date will depend on the type of data they hold. For health data users, so for the applicants for secondary use, it's the same system. So from March 2029, they may apply to health data access body for access to most of the categories of health data. And as of March 2031, the access will expand to more sensitive data such as genetic and clinical trial data. So this transition period, it may seem long, I would say, but there is a lot of work to be ready actually for all stakeholders involved. So for member states, healthcare provider, and the Commission itself. So this explains why it will take some time. So now to finish this session, let's have a look, Sarah, at the EHDS to-do list.
Thank you. And I'm going to deal with some of the questions that have popped up during the session within the to-do list. So the first thing, this to-do list assumes that you have determined that this legislation applies to you, but there is that first important step to determine the applicability, to doing an assessment to decide that this applies to you. One of the questions talks about, well, you know, what does being established within the EU EA mean for the purposes of this regulation? And that's an important assessment that needs to be done initially. There's no particular definition of establishment within this regulation. It's referred to frequently, sometimes fairly informal language. So having an established presence is used a couple of times. So that is an important assessment that would need to be done first. Then when we have determined that this applies to you, then there's various things that clearly have to be done when you've gone through all the obligations effectively within the legislation. So firstly, data mapping. Obviously, you'd need to be certain of what data within your systems that will be in scope. Then assessing the role of third parties, as Sonia mentioned, there is some interoperability between this and other regulations. So particularly where third parties involved, there are GDPR type issues that need to be considered, contracts that will need to be reviewed, and determining other aspects of obligations that might be relevant here. So that exercise will need to be done. As well as data mapping, you probably need to be doing data cataloging, which we're saying is sort of descriptions of your data sets. So, you know, where are they? What's their scope? What are the main characteristics and conditions for using the data to be able to deal with the following obligations really under the legislation. As Sonia mentioned, you'll be wanting to protect any IP involved, identify which protections apply to the health data that you have, and prepare to be able to protect that using the processes Sonia referred to. And then you're going to have to be looking at compliance with the standards that are going to be implemented here. We're expecting further guidance. The Commissioner said it's going to be using liaising with member states and relevant parties about, you know, frameworks and security standards, but you're going to have to ensure compliance with those standards. This is about data quality and utility labels, which are mandatory. Then data preparation, you'll have to prepare the data for sharing, ensuring it's in a secure processing environment and ready for use. And then if we go to the next stage, there's a similar following to-do list. So ensure that your systems and processes are compliant with the technical requirements. Further information may well be available, probably by 2029. You're probably going to be having to phase out legacy systems, prepare for additional data categories that are going to come into play, integrate extended secondary use categories, and then this refers to another question. By March 2034, it's expected. This is preparation needed by third countries and international organisations that can officially join the infrastructure for secondary use. So the question about non-EEA established entities and their involvement within this. The FAQs deal with this, and there's more to be done effectively. We need to be looking at countries either being recognised by the Commission as having reciprocal health data sharing arrangements, or applications which will be sort of 10 years after the regulation coming into force by countries to take part in this infrastructure, and then those that aren't, you know, directly caught by this regulation being able to take part in the research, accessing secondary use for research, etc. So it's fairly significant to-do list, and inevitably with this, not just preparation now, that you may think you've got some time, but, you know, experience from other regulations has indicated the time disappears. You've got the preparation to do now, but also as your processing changes, as your data sets change, you know, it's an ongoing process to make sure any future data is also compliant within these systems, with fairly significant obligations to do this, really. So that's the end of our to-do list that we think needs to be done at this point.
Thanks, Sarah and Sonia. So we are reaching the hour. So unfortunately, we don't have any more time for questions. But if you do have questions, don't hesitate to reach out to us and we'll be more happy to have a discussion with you. Goodbye.